Hello and welcome to the final Employment Law Live of 2021. I can't believe it's December and we're getting rid of this year, hey? What's to come? So I'm Sarah Potter and I'm your host for today's webinar on Employment Law Live, and I'm joined with David Sillitoe, who's a solicitor from Robinson Ralph. So welcome, David.
Hello, Sarah. Thank you very much. Hello, everybody. As Sarah says, I'm a solicitor at Robinson Ralph, so I just do employment law, I've been doing that for far more years than I care to remember now, but about 17. And we focus on employers and supporting HR departments in implementing the policies and procedures and helping them through difficult grievances and disciplinaries and dealing with any tribunals as well. We sort of take the approach that we very much aren't there to run people's business for them or give them overly cautious advice, but to give you the options to make to enable you to make the right decisions for the business.
Brilliant. Thank you very much, David. So we've been working together for about the past 2 years now.
Scarily, yeah.
I know. Back when we were face to face, remember what that was like? Crazy.
I know. I can't wait to get that back.
I know.
Yeah, hopefully in the new year.
New year. Yeah, brilliant. So we've been working together, Peer Genius and Robinson Ralph, for about the past 2 years now. So they are our employment lawyers, which are our go-to suppliers. So the reason why I like working with Robinson Ralph, if you follow these guys on LinkedIn and across social media, you will see that humour is one of their values. So they aren't the average employment law solicitors. They aren't robotic in their delivery, so it is very much layman's terms. So if I can understand it, then anybody can. And the third reason is that they don't hold you to ransom with their sort of high retainers. Their piece of work that they do for you, they do execute it as if it is their first and last. So they want to have that long-term relationship with you. So David, if I give you over to you for the disclaimer, and then we'll go into today's topic, which is fire and rehire. So really excited to hear your expert tips on that for today.
Thank you, Sarah. Just to clarify, when Sarah says that we're not average, she doesn't mean we're below average. Just to clarify that there. Disclaimer that Sarah mentioned is that this is, of course, a webinar. This is not legal advice. I'm speaking to you to give you information. Don't make any decisions, any policies based on the information that you've heard in a webinar, because should it all go wrong and you subsequently have to defend that to the powers that be, I can't imagine while I was listening to somebody speak generally on a webinar on LinkedIn and Facebook and so on is going to cut much mustard. So if you do have a particular process planned that relates to fire and rehire, if you think that you might need to take advice on that particular situation, then do so. You can contact us at Robinson Ralph, of course, or use other employment lawyers. If you want to contact Robinson Ralph, it's info@robinsonralph.com. So shall I crack on with the talk, Sarah, on fire and rehire?
Brilliant. Yeah, so we're going to be here. It's quite sort of quite quick fire, really. So we're going to be here for about the next 15-20 minutes, but we want to keep this as interactive as what we can. So this is your time. So feel free to fire any questions over to David and I'll put them to him. So yeah. Over to you.
Absolutely. Yeah, do put them in the chat. Sarah will pick them up. Brilliant. So yeah, fire and rehire. Well, it's long been a controversial method and is usually used as a last resort. Certainly not a sort of commonly regarded as a best practice as such. It doesn't generally promote strong company culture, but it's recently attracted some publicity and some criticism and some media attention, particularly over the last few months when the TUC brought attention to the practice becoming widespread in response to financial circumstances caused by the pandemic. We have to obviously bring everything back to the pandemic if we can. So
we're talking about it, don't we?
Oh, it's brilliant, isn't it? Yeah. So the TUC's perspective on this was that the rights of many staff were under attack. And of course, fire and rehire can affect any type of employee, but principally in the situations that the TUC was highlighting, it was affecting low-paid workers. British Gas was an employer that attracted quite a lot of publicity and ire because of it, but there were also Go North West bus services and NHS trusts that were using the practice and came in for some criticism. So the Prime Minister waded into the debate and described the practices as unacceptable, but ultimately the government insisted that firms in financial difficulty must retain the ability to have flexibility to offer new terms and conditions, and that must be right. In my opinion, it would be overreach for fire and rehire to be outlawed as a practice. Which part would be outlawed? Businesses' abilities to fire? Well, surely not. Their ability to rehire people afterwards? Well, how would that help anybody? In Spanish law, there's a law that any new contract must be at least 50% of the previous wage, apparently to avoid financial manipulation. Such a law could be introduced over here, but it wouldn't affect the vast majority of fire and rehire practices where pay isn't being reduced by anywhere near that amount, if at all. In Spain, it did affect Lionel Messi. He was forced to leave Barcelona because despite generously agreeing to a salary reduction of 50% to a mere €1 million per week, the club still weren't able to keep him, and by law his salary couldn't be reduced any further. So the poor little lamb had to move to Paris, where he only earns €750,000 a week. So maybe we'll see something like that here, but I doubt it. So in response to all this hullabaloo, ACAS were asked to conduct a fact-finding exercise into dismissals and re-engagements, and they published evidence on the use of fire and rehire practices at work in June of this year, that's 2021, following a request from the Department for Business, Energy and Industrial Strategy. So they the government then, in response to those findings, asked ACAS to produce clearer guidance to help employers explore all other options first before considering fire and rehire to change employee contracts. So that was published a couple of weeks ago, 11th of November, and it focuses on employers maintaining good employment relations and the importance of seeking to reach agreements with staff and trade unions before imposing fire and rehire. So again, that ACAS guidance, it's not legal advice, but if you are, as an organisation, looking to implement contractual changes and potentially using fire and rehire as a fallback option, then you could do yourself a favour by having a look at the ACAS guidance, because following the principles in there will be relevant, and by saying that you have had regard to it and followed those principles, you will look better in the eyes of a tribunal. So ACAS found that the circumstances where the practice was used included redundancy scenarios, harmonising terms and conditions, or it could be introducing temporary or permanent flexibility into contracts in terms of working hours, shift patterns, payment entitlements and security of hours or employment, and also negotiations around organisational responses to changes in consumer behaviour, sectoral changes or changing operational needs. So the findings of ACAS demonstrated a wide range of views about the perceived reasonableness or otherwise of fire and rehire where it occurs in different scenarios. There was no single shared perspective. Some regarded its use in any circumstance as unreasonable. Others expressed concern about the imbalance that fire and rehire brings to negotiations when threatened as a negotiation tactic. And there was a further perspective that the practice can be reasonable only if used as an option of genuine last resort. Others felt its use was not necessarily contentious, provided it's driven by a genuine business need and preceded by negotiations attempted in good faith to reach agreement before imposing the changes. So obviously there are a wide variety of views on it. Probably depends on perspective that you're coming at it from. I don't imagine that very many businesses at all will engage in fire and rehire lightly, unless it is really an alternative, and they will have regard to the implications for the workers and their relationships with those workers. So the ACAS chief executive, when producing the guidance, said that the new advice is clear that fire and rehire is an extreme step that can seriously damage working relations and has significant legal risks for organisations. An employer should thoroughly explore all other options first to make every effort to reach agreement with staff on any contract changes. Organisations that consult with their workforce in a genuine and meaningful way about proposed changes can help prevent conflict at work and stay within the law. And I think those three sentences there should guide your approach to any negotiation, any consultation where fire and rehire is a potential outcome. So how should a business implement that advice if faced with the possibility of having to use fire and rehire or enforce changes to contractual terms? We're supposed to learn that ACAS say that you should consult with all affected staff and all their representatives in a genuine and meaningful way. So this will involve having a clear business case or rationale for why the changes to terms and conditions are necessary and demonstrating what alternatives have been considered. In terms of the claims that can arise, well, principally, that would be a claim for unfair dismissal, where the employer terminates employment and the employee might seek compensation. If they seek compensation, the employer may be able to argue that the employee has failed to reasonably mitigate their losses by not accepting the new contract. But in fact, what the employee can do is seek reinstatement on the original terms. And reinstatement is supposed to be, although it's not very often a remedy that's sought or granted, it's supposed to be the primary remedy in an unfair dismissal claim.
Cool.
The employee may also claim constructive unfair dismissal in anticipation of any proposed breach of contract. It's not ordinarily the case that there'd be any contractual claims because notice will be paid, holiday pay will be paid as well. But in order to protect against any claim, really, an employer needs to start thinking about the risks, thinking about the approach they're going to take at a very early stage and identify the legal basis, that is the potentially fair reason for any dismissal. And that'll be particularly important, of course, where most or some of the employees have more than 2 years service. So ACAS advised that you should consider what issue you're trying to solve and whether a contractual change is definitely needed to solve it. Consider the alternatives first. So, for example, if you're looking to reduce business costs, you might look at how you can improve ways of working or make savings elsewhere before considering potential contractual changes. And exploring those options and being clear about why a contract change is in fact needed will help when it comes to informing and consulting with employees and representatives about any potential changes. And identifying the potentially fair reason will guide how you proceed. Most likely that reason will be either redundancy or some other substantial reason. That's some other substantial reason. SOSR is the fifth potentially fair reason in the Employment Rights Act. And SOSR can encompass a business reorganisation or restructure which doesn't fulfil the definition of redundancy. Redundancy will be applicable where there's a reduced or ceased need for employees to carry out work of a particular kind, either overall or at a particular location. So I think probably in the vast majority of cases it's going to be SOSR in a fire and rehire situation, because if it was redundancy, then you'd simply be dealing with it as a redundancy situation. But you might plead redundancy if defending any subsequent claims in the alternative. With SOSR, as long as the employer has a sound business reason for dismissing an employee who refuses to accept a change to their terms of employment, it should be able to establish SOSR. Substantial, the word there doesn't impose a huge standard, a very high standard there. It doesn't need to be severe that the very survival of the business is at risk, just as long as there is a sound business reason. It doesn't have to be a reason that the tribunal considers sound, but one which a reasonable employer would consider sound as found by the tribunal, which might be semantics, but that's the way that the law works. So tribunals aren't able to substitute their own opinion for that of the employer on the question of whether the change is advantageous to the employer's business. And that's the same with a redundancy decision. Employers are entitled to make bad decisions or decisions with which their employees do not agree. And how strong, though, having thought about whether or not it's redundancy or some of the substantial reason, how strong that purported fair reason is, or how pressing the business need is, may well guide how an employer approaches negotiations. And if there is a lack of confidence on the employer side, you may not decide to even mention fire and rehire, not even to go down that route at all, because if you are going to mention it, you're going to have to be prepared to follow through. And if you're going to be prepared to follow through and you do so, you're going to face claims. And if you don't think you're going to be able to defend them, then, well, you could go ahead, but that's a bit gung-ho. Another consideration should be whether or not any discrimination issues are likely to arise. So, for example, it could be unlawful discrimination if you change an employee's contractual working hours, and that makes it difficult for them to effectively manage a medical condition. It's considered a disability. Additionally, somebody could be a primary carer, and their new hours, the proposed hours, may well not be hours they can fulfill. So again, how imperative or fundamental the business need is will need to be considered, and any claim is likely to be for indirect discrimination or perhaps failure to make reasonable adjustments. But in both claims, the employer's interest in implementing the change will be balanced against the discriminatory effects on the employee. So it may be that you can still implement the change. It may be that you need to make adjustments in respect of a particular employee, or it may be that you decide the risk is so great or the business need isn't compelling enough that you decide not to proceed with the change at all. I mean, more commonly, I'd suggest it's likely to be the former, where you just make changes in respect of an employee. So if the business proceeds, then consultation with the employees will significantly strengthen the defence to any subsequent claims. So that'll be making the employees aware of what's being considered, giving them the opportunity to propose alternatives, and if relevant, consulting with trade unions. Doing so obviously helps protect against claims, helps defend claims if they arise, but also it helps maintain employee relations. And it may well be that you are able to seek agreement. And one thing that we've seen and have discussed with a number of clients is, well, if you're proposing contractual changes, I mean, obviously it depends on how fundamental these are, but it may well be that you can present a positive picture of the changes themselves, or why the changes are necessary, or the implications that can be avoided by implementing the changes. If you can, it may well be that you can get agreement relatively easily by a lot of employees, perhaps through just writing to them and asking them to write back and confirm the changes, or going through some sort of online process where they check a box. And then you may well be able to isolate the risk and say, well, look, these are the employees that we need to consult with. These are the employees we need to be able to persuade. And it may well be that after discussing things with them, you are able to persuade them. But if you're not, then at least you know where your risk lies. And in an ideal world, you've brought a lot of the employees, or the majority of the employees, along with you. If the changes aren't agreed through consultation, obviously you'll need to either implement those changes through unilaterally varying the contract, or firing and offering re-engagement on new terms. ACAS suggests that it's harder for both sides to reach a negotiated solution if employees feel threatened by an employer. So I think the way to pitch possible outcome being dismissal with an offer of re-engagement, which is the proper legal term really for fire and rehire, is that is the last alternative, not something that we want to, but we will need to do it. As an employer, we will need to do that if change can't be agreed for these compelling business reasons. And again, it comes back to just trying to take the employees with you and get them to understand, even if they don't agree with the decision. Obviously, doing that avoids reputational damage as well. And I think what I believe is, generally speaking, a market where recruitment is difficult, having a reputation as a constructive, understanding employer is important. And that can be maintained, I think, if this sort of consultation is done in the right way. And obviously, another risk is that you lose valued people who don't accept the new terms.
Yeah, and with that,
Um,
you can't ever communicate enough to people at all.
yeah,
With
yeah,
that, if you think on your communications plan, we've got the point across, you can't. Obviously, all your consultations need to be really meaningful as well, because you do want them to feel valued and feel listened to.
yeah, absolutely. And on that note, what should you tell them? Well, what the proposed changes are, who might be affected, why the changes are needed, the time frame for the proposed changes, other options that have been considered. Provide that information clearly, provide it at an early stage as possible, really. Now, obviously, you'll have commercial considerations to factor in. You won't want to do it too early, but as early as you reasonably can. Explain the options, be as transparent as possible, and taking an approach that's working together to try and find a solution, and keeping employees informed is absolutely vital. And also just bear in mind, if you are going to potentially be dismissing, if you propose to potentially dismiss 20 or more employees, then you are going to have to go through collective consultation before you can terminate. So one, you'll need to be aware of the obligations that collective consultation gives rise to, and two, you'll need to be aware of the timescales from the start of collective consultation to when dismissals can take effect. Collective consultation, I think, is probably another webinar in itself, so we won't go any further than that.
And even though you've got those tick boxes that David said, like try the human approach to it as well. How would you feel if you were in this situation? And just make sure that those meetings and those timings, you're taking the time to write people's comments down, get back to everyone in a timely manner as well. So like you said, you want to keep the engagement as high as possible. And I know when I've executed just redundancy, they've thanked me through the process, because it's been a hard process, but we've actually made them feel valued throughout.
I wondered where you were going to go when you said that you'd executed, but it was a redundancy situation.
Yeah. But again, it's just that human approach. How would you feel if you were like on the receiving end of this? And like you said, we want to increase their engagement to be on board with the new changes.
Yeah, absolutely. So yeah, I think a couple of final points really. Just to sum up. If you're going to go along the fire and rehire or dismissal with an offer of re-engagement route, then just make all reasonable attempts to reach an agreement through a full and thorough consultation. And bear in mind that if you're proposing to dismiss, then you need to have your ducks in a row. It's no good just thinking at the end of the process, gosh, is this going to be fair? You need to be thinking about what steps you need to go through to ensure that any dismissal will be fair. So what's your fair reason? What's the process of consultation that you're going to follow? Are we going to be liable for statutory redundancy pay? What's our notice obligations going to be? Are we going to pay in lieu of notice, or are we going to make people work their notice? We're going to have to pay them accrued holiday. So it's not cheap doing that. And finally, are you going to offer a right of appeal as well? Now, the ACAS Code of Practice on Disciplinaries and Grievances doesn't apply to these sorts of dismissals, but it will certainly help to defend any claims, and it would be generally best practice to offer a right of appeal. Whether it be necessary depends on the circumstances, but it's certainly something to consider.
Fabulous. Well,
any questions, Sarah, or have we
no,
made it
I think
so compelling that nobody?
Yeah, that was really, really helpful. So yeah, like I said, I understood it. So well done. You passed that test.
Maybe you can explain it to me later. I had no idea what I was saying.
No, that's brilliant. So thank you so much. Like really informative. So thank you so much. So if we haven't got any questions for anyone, we'll end the session just there. So thank you for everyone for joining us. And we will be back on Thursday, which should be the 7th of January. So
oh my gosh.
I want to take the opportunity to wish everyone keep safe and have a great Christmas, and make sure you get a rest. We don't know what's going to come next year. Thank you very much for someone putting their thank you message over to us. And David, did you want to say goodbye and thank you to everyone too?
No, I'm incredibly ungrateful. So no, but yeah, no, thank you to everybody for joining us. See you in 2022, which is absolutely crazy that we're thinking of that. But yeah, have a great Christmas.
Yeah, brilliant. Thank you very much, David. And we'll see you in the new year. Take care, everyone. Bye.